All right. So welcome. And then any of you listening to this, welcome to you as well. So this is a seminar for the month. We're talking planning for the future, especially as it relates to children with special. By the way, I use the word child. I know that, and we just talked about this. I know that not all of your children per se are actually children. A lot of them are grown adults, but it's just easier. So if I say child and yours is not a child, please don't be offended. It's just easier as we go through because I know we're going to be talking about children, quote unquote, of all ages. So, at any rate, just talking about planning for the future. For those that don't know me, I am Jonathan Nobles. I practice here in Raleigh, North Carolina. Just a little bit about how I got involved with the special needs community because I actually also practice immigration and family law. I have a heart for the special needs community for a couple of reasons. One is because my wife has been working with a nonprofit here in the area that works with special needs, provides employment for those with special needs. She's been working with that organization for about 6 years now, and I help out when I advice and I help with some of their marketing, et cetera. Really love the community. And the other thing is I do family law, and really to me, this is just kind of an offshoot of because these are all families and they're families with specific challenges and they need help with them. So I just kind of thought this was a natural fit for me when I started my own practice. So that's me. And let's talk legal planning. So why legal planning actually matters. So you may be aware of this already, but once your child turns 18, everything changes because you as a parent lose the right to just automatically make decisions for them. All of a sudden, you go to the doctor and the doctor says, I'm sorry, I can't tell you what his condition is or what's going on unless he gives me permission to do so. And we'll talk about how to get that permission in a minute, but it's not automatic. And a lot of parents are really taken aback by that. And they think, well, why shouldn't I be able to make decisions for them? There's obviously someone needs to help them. And that may be true, but in the eyes of the state and in the eyes of the state courts, there is what we call a rebuttable presumption of competency. So as long as a person is 18, the state says we're going to assume they're competent to make their own decisions unless you can prove otherwise. And so the burden is actually on whoever wants to challenge that and challenge it a good way. Sometimes it can be bad, but anyone who wants to step in and say, okay, they can't make decisions for themselves and here's why, and somebody else needs to do it, that's what has to happen. So there are legal tools that are needed to protect their well-being and for someone to step in and make those decisions for them. So that's what we're going to be talking about over the next few minutes. So let's talk about guardianship. And these may be some things that you're already aware of. So, but just for purposes of the recording, I'll go ahead and go through everything and then talk about specifics after that. So guardianship, just in a nutshell, is a tool that gives legal authority to make decisions for someone who, as we just talked about, can't make decisions for themselves. There are two types of guardianship, well, really three, if you combine the two. So there's guardian of the person, which that gives the guardian the right to make decisions about their health and well-being, the medical decisions, those types of things. And then there's guardian of the estate that allows the guardian to make financial decisions essentially for the person who under the guardianship. And then there's general guardian, which basically combines the two. 99 times out of 100 in this setting, it's going to be both of them. So you're going to be applying as the general guardian. There are some cases where they might be one or the other, but if that's the case, probably there's some other tool that may be more helpful. So generally speaking, when we talk about guardianship, we're talking about someone, usually a parent, applying to be the general guardian of the child with special needs. So let's talk about the process and how that works because it is not simple, easy, or short, and that can probably be attributed to just about anything that involves the court system. But guardianship is something that is pretty involved. So the basic steps at a very high level, first thing you have to do is file a petition. So whichever parent wants to be the guardian has to file to do so. And then the respondent, who is the child, has to be served. Now, obviously, in some situations, the child may not understand what they're being served with, but technically they are the subject of the guardianship, so they have to be informed. And just as an aside, there are some cases where you may have a child who is, or even a young adult who is being, the parent has applied for guardianship, but the child says, wait a second, I don't need this. I think I can make my own decision. So there are cases where the child can challenge the guardianship and might say, this is not something I need. But in most cases, with what we're talking about, your child is capable of. And so, generally speaking, guardianship makes sense, but they have to be served. And then a guardian ad litem, or GAL for short, is generally appointed by the court. And that's another attorney that is appointed by the court to make sure that the child's best interests are being represented. Because your attorney, whether that's me or someone else, is going to be representing you as the petitioner. But then somebody needs to look out for the child. And again, not that this is supposed to be adversarial by any means, but just the court just wants to make sure that whatever is in the best interest of the child, because that's always the standard. They just want to make sure that it's always taken into consideration. So the guardian ad litem is appointed to represent the child. Evaluations are submitted. So you may have the child's doctor or the child's psychologist or any other professional that you've worked with that can attest to what your child is capable of and what they're not. And in some cases, a sworn affidavit might be enough. You might need actual testimony from these experts to make sure the court understands what their capabilities are and that they really should be declared incompetent. And obviously, I don't mean incompetent in a bad way, just from a legal standpoint, that they're not competent enough to make their own decisions. And then there's a hearing. Usually in North Carolina, these aren't before a judge per se, they're before the county clerk. So here in Wake County, for example, it would be a hearing before the Wake County clerk, and the petitioner would present their evidence. The guardian ad litem, after spending time with the child, will potentially present evidence and make their recommendations. And then the clerk will decide two things. First thing they will decide is the child actually competent or not? And if they're declared incompetent, then it's a matter of who should be the guardian. Now, generally speaking, especially in a situation where you have a child where there are, for lack of a better way of saying it, obvious challenges, 99 times out of 100, they'll be declared incompetent from a legal standpoint, and the parent who petitioned will be appointed their guardian. However, there are situations where the court may decide, okay, mom or dad, you're the one that filed this petition, but we really feel like the other parent, if you're separated, or another family member, or someone else should actually be a guardian. And that also gets us into something I didn't mention before with the petition. Two types of guardianship, in the sense that there is uncontested guardianship and then there's contested guardianship. And those are pretty self-explanatory. Uncontested guardianship is where basically everybody agrees that mom should be the guardian of the child, or dad should be the guardian of the child, or if the parents aren't involved, another family member who is taking care of the child, who has basically been their de facto guardian as they've grown up, should be appointed their guardian. But in some cases, you may have other family members that challenge that and say, no, I should actually be the guardian. And the most obvious situation there would be if you have a situation where the parents are no longer together and they're not really on the same page when it comes to what the child needs. So let's say, for example, you have mom file for guardianship and dad says, no, I think I should be guardian. Or dad may say, what, he or she doesn't need a guardian. They're perfectly capable of making their own decisions. And so that's when it kind of becomes contested. But most of the time, again, with a child with obvious challenges, it's going to be an uncontested guardianship. They're going to be declared incompetent, and the whoever petitioned for guardianship will be appointed the guardian. Now, in terms of time, it's hard to say. We usually recommend that people start this process 6 to 12 months at least before the child's 18th birthday. Now, if you waited and haven't done that but still think this is necessary, it can obviously be done after the fact. But that's generally what we recommend, just so we can get all the court stuff done, and that way there's no lapse. So if you've already been appointed guardian before they turn 18, then essentially nothing changes and you can continue to make decisions for them. So that's guardianship. But there are some less restrictive alternatives to guardianship, and these would be appropriate for kids who are capable of making at least some decisions themselves. Again, you as a parent probably already kind of know, for the most part, what your child is capable of and what they aren't. Some may be capable of themselves, getting themselves ready for school, all of those types of things. They can get around, they can use rideshare even, or get rides with friends. They're pretty independent, but maybe they don't really know how to handle a checkbook, and they don't really know how to handle their finances. So that's where maybe they're not comfortable talking to the doctor. They may come to you and tell you, Mom, Dad, I know I'm 18 and I'm supposed to be talking to the doctor about my own situation, but I'm just not comfortable doing that. So I would rather you do that for me. That's where these alternatives come in. So durable power of attorney. Most of us know what a power of attorney is. You're basically voluntarily giving someone else the right to make decisions for you. And that's what's really key about all of these on this page, is these cannot be used by someone who doesn't understand that they have rights, what those rights entail, and that they're voluntarily giving them up. So for example, if you had a child with very severe developmental disabilities, power of attorney wouldn't work because they're not competent enough to sign away those rights. But if you have a child, again, who understands what rights they're giving up, I'm giving my parent, this particular person, the authority to handle all my finances, or to speak to the doctor on my behalf, or whatever it may be. But they have to understand what's going on. So durable power of attorney, it's kind of a general catch-all vehicle where the person can sign away their financial rights, their rights to buy and sell property, all those types of things that are kind of non-medical, if you will. Usually this is done for financial purposes, and they can sign away all of those rights, or maybe just individual rights. It can get very specifics, like, hey, I can do everything except this. So this is all I'm giving the authority to do. But when they sign it, it gets notarized, and the person has the authority to speak for them. Healthcare power of attorney, just like it sounds, that is giving someone else the authority to make health decisions for the child. So this is the ideal vehicle for a young adult that it just isn't comfortable speaking up for themselves with the doctor or the dentist or the psychologist or whoever it is. That's what this is for, and you can do both. And then there's one specifically for mental health, but advanced directive, generally also called living wills. Someone says, if I'm in a situation where I'm incapacitated, can't make decisions for myself, this is the person that I want to make decisions for me. And that can also be customized. But again, these are options that only work if the person understands what kind of rights they're giving up. Another key to these, especially with the durable power, well, really with any of these, because the person is voluntarily giving away rights, they can voluntarily take them back, and they can say, okay, you know what? I kind of feel like I can handle the doctor now, or I don't like the way you did this. I'm going to give it a go myself. So they can revoke the durable power of attorney or the healthcare power of attorney. And just because a healthcare power of attorney or a durable power of attorney is in place doesn't mean that they can't speak up for themselves anyway if they want to. And obviously that would be a conversation for the child and the representative, where you say, okay, I'm signing this, but it's basically just to break glass in case of emergency kind of thing, in case I get into trouble. I want to do this on my own, but I want to have something in place to where if I do struggle, then you can just automatically step in without me having to do anything else. So these are very, very flexible and can be very, very structured as long as the child understands what they're doing, what they're giving up. Also, these can't be executed by anyone under 18 as well, simply because the courts generally assume that regardless of how mature they are, how developed they are, that someone under 18 is not competent just by default to make their own decision. So you don't need any of these and can execute these for a person who's under 18, but once they turn 18, if they can take care of themselves, then this is something that you might want to consider. All right, so that's guardianship and power of attorney. Now let's talk a little bit about some planning tools from a financial standpoint. And we won't belabor these, but we kind of want to do kind of a very high level look at some financial vehicles, and then we can talk more about them if need be. So first one up is the Special Needs Trust. So the Special Needs Trust is a really neat tool to protect eligibility for benefits while setting aside funds. So as you may be aware, a lot of benefits that those with special needs are eligible for, whether that be Medicaid, SSI, something like that, those are means tested. So if your income is above a certain level, you don't qualify anymore. So this and the next one we'll talk about are some really neat things you can do to make sure they have money for the future. Well, and even for day-to-day stuff, but make sure that they have money and that they're taken care of without affecting their eligibility for those types of benefits, because the government doesn't look at what's in the trust when they are determining eligibility. So and the money that's in the special needs trust can be used for any non-food or shelter expense that supplements public benefits. So educational type benefits, other types of things. The money can be used for that. Because it's a trust, and this may be obvious, a special needs trust has a trustee. So in other words, somebody is still making decisions for the beneficiary, which is the child in this case. They're not making the decisions as to what to do with the money themselves. The trustee does that. So they have to rely on the trustee to make disbursements as necessary and make sure that the money is managed properly. So if they feel like they need something, they would have to go to the trustee in order to get that. And anyone with a disability can have one. So this isn't just those that can make decisions, those who can't make decisions. This is an ideal type of planning vehicle for anyone that has a disability. And this also can be incorporated and it's one tool that can be used for estate planning purposes. So, for example, you can draft a special needs trust that says, okay, upon my death, whatever is in my estate is going to my child, but it's not going to them directly, it's going into the trust. And others can contribute to the trust as well. So I have people that have created these so that grandparents, for example, can leave their inheritance of the grandchild. They can leave money and it goes in the trust without having to give it to them directly with all of the consequences that may entail. So it's a great planning vehicle. There are a couple of types. There's the first party special needs trust. So if the child already has assets, so let's say they've already gotten an inheritance or they have money for whatever reason, it can be started with the child's assets. But in that case, if they have Medicaid, they can still stay on Medicaid, but upon their death, Medicaid has to be paid back for whatever benefits were used while they had Medicaid. So out of their estate, Medicaid has to be paid back. A third-party special needs trust is one that is funded by someone else, the parent, the grandparent, the aunt, the uncle, the family friend, whoever it is that puts money in the trust for the child. And in that case, Medicaid doesn't get paid back. So that's why we generally, and most of the time, the child doesn't have those kind of assets anyway. So generally speaking, if you're going to do this, we feel like the third party special needs trust makes the most sense. Not only because no Medicaid payback, but also it gives the opportunity for multiple third parties, regardless of who the initial grantor is. You might have one person who funds the trust initially, but others can, as I said, they can put money in as well. And it protects eligibility while the child is alive. And then upon their passing, their full estate can go to whomever without Medicaid having to be paid back. So special needs trusts are really ideal for, as we said, inheritance settlements. Maybe your child was in an accident and they receive a large settlement. And so that money can be placed in the special needs trust. High value gifts or real estate, someone gives them a non-cash gift, which is very valuable, a house, piece of property, et cetera, that can go in the trust. As I said, that money is going to be left upon their death to whoever they have in their estate plan. So it's long-term planning across generation. And if you have assets where it's a little complex to protect them, the trust is a great vehicle. Also, as with any trust, and I will say right up front, I don't do a lot of estate planning. I don't consider myself an estate planning expert. I know a lot of good attorneys who do estate planning, but I do the special needs trust because it's a great tool for this community. And I will say that it is a great part of any estate plan because, like any trust, it helps avoid probate. So, and that to say, it just makes it easier upon the passing of the child. There's a will, the trust is included, then it's already spelled out who's going to get what. And it's not something where a will can be contested. If it's in the trust, it doesn't go anywhere with the passing of the child. It stays in the trust. And the trust is structured so that there's not that long drawn out court process that there sometimes can be when you're trying to execute a will. So again, I can put you in touch with estate planning attorneys who are really, really good at this in terms of the long-term effects, but the special needs trust is a great tool to use. Another one is the ABLE account. And I have forgotten what ABLE stands for. I had that in my notes somewhere. But at any rate, the ABLE account, it's something benefits for living something. Anyway, but ABLE's a great program. It allows the beneficiary to save up to $100,000 without impacting their eligibility for SSI. So this is another tool that helps you stay under the radar, if you will, and qualify for benefits if you have assets that would put you over the threshold. So and we recommend using it alongside a trust because they're good for different things. Not everybody qualifies for an ABLE account. The disability had to have been present before the child turned 26. My understanding is that's supposed to go up to 46 next year, which would be very good. And it has to be used for qualified disability expenses. And there's a lot of good information on the web about ABLE and how it works specifically in North Carolina. They're ideal for day-to-day spending. So it's a little easier to kind of get money in and out of the ABLE account as opposed to the trust. Disbursements can be made from the trust, but it's just a little more involved. And if you only have modest funds, maybe they're able to work, so you have work income, small gifts, this is probably a better place for them. And if you have someone who, again, can understand, make financial decisions for themselves, they can manage their spending, and it's a flexible, low-cost option. It does have some tax benefits as well. So the ABLE account, definitely another planning tool to use for financial purposes. And again, I don't deal with ABLE accounts that much, but I definitely can put someone in touch with those who can help create the ABLE accounts. And then what I can do is make sure that ABLE account is connected to, if you will, or it's a compatible part of whatever other planning that you're doing. So that's where I would come in when it comes to the ABLE accounts. This isn't really a planning tool per se, but it's just something I wanted to throw in here because I hear a lot of people as I go to different events with the special needs community. I've had people talk to me about how they feel like the school is not giving their child what they need. They're not honoring their IEP. They're not making the they're not putting the things in place that they're legally supposed to be doing for their child. So that's another place where I can be of service. I can advocate for your child, for you and your child, and say, look, under the law, this is what you're supposed to be doing. And if you're not doing it, that needs to change. So that's something that we can do as well. Just a couple of things related to the law that every parent with a child with special needs should be thinking about and to understand. One, your child is entitled to free, appropriate public education. So their education, they get a free education just like every other child, but that education should be specifically tailored to their needs. And it should be an individualized education program. I'm sure most of you are familiar with IEPs. You probably know more about them than I do because you deal with it all the time, but you have the right to have that IEP in place. They should be in the least restrictive environment, which means that, yes, on the one hand, it should be appropriate and consideration should be made, but at the same time, they should be treated as if they were a typical child as much as possible. So it's that delicate balance, and admittedly, schools sometimes struggle with this, but hopefully they're trying to make it work where your child is getting what they need, but they're also being exposed to, for lack of a better way of saying it, a normal education with everybody else. So you definitely don't want them being overwhelmed, and you want them to get what they need, but at the same time, you don't want them isolated either. So that's something that's a tightrope that the school is really supposed to walk, and we can help them make sure that they're doing that. There need to be procedural safeguards in place, legal protections for parents and children. You should have the right to participate in meetings, access to educational records, the right to due process hearings and complaints if something is not being done the way it should be done, and the right to an independent educational evaluation. So if necessary, bringing in a third-party expert to evaluate what's going on so that they can say, look, these kids are not being treated, they're not getting the type of education they're supposed to be getting. So this needs to change. Child find, schools must actively identify and evaluate children with disabilities, even if they're not yet enrolled. So the school is supposed to be aware of what the challenges are that the children have. And of course, obviously, I think just about all parents are going to make sure that the educators know what's going on, but the school should be aware of that, and they should be proactively looking for situations. And frankly, they may spot something that you as a parent aren't aware of. They bring it to your attention, and it's something that everybody can work on. And then transition planning. So in North Carolina, by age 14 or earlier, they're supposed to start with some type of transition plan that starts looking at the possibility of post-secondary education, vocational training, employment, independent living. So basically, there needs to be a plan in place. And that's something that not only, obviously, you as a parent are primarily going to be responsible for that, but the other educators in your child's life should be cooperating with you and working with you in order to help develop that plan for your child so that they have as seamless a transition as possible from high school to whether it's college or vocational training or a job or whatever it is, that they can take care of themselves to the extent minimal interruption. And then we mentioned long-term financial planning already, but you want to make sure that, your wills, your life insurance, relatives, all of those things are incorporated. And this letter of intent, which is kind of like a will, but a will is more for what happens if I'm gone. I think the letter of intent is more a matter of these are the things that need to be dealt with and accomplished. And this is where we're trying to get with my child's financial plan, and make sure that anyone who could possibly contribute to that financial plan, if they have an account, make sure those at the bank kind of know what's going on. And that way you can kind of say, this is where we all want to work together and make sure that we get here for the sake of your child. So just real quick, lastly, things that I can help you with specifically. Guardianship, that is definitely something that I can help with, not just because it's me. There are a lot of things that you can do without an attorney. And there are a lot of these things that you can do without an attorney. I would not recommend going through the guardianship process without an attorney simply because it can be cumbersome and you don't really know what you don't know until you get involved with it. So I would say it's at least worth a consultation if you're considering guardianship. My consultations, by the way, are always, the first one's always free. So it's always worth, let's have a 15-minute conversation about it, see if I can help you. If you think you can do it on your own, I am certainly not going to disagree with you because you have the right to do whatever you feel is in the best interest of your child. And that's really all I want as well. But if I can help, I'm certainly going to tell you what I think some of the pitfalls are and what you need to look out for. And you may decide, hey, maybe I need you to help me with this after all. So that is something I can do. Powers of attorney, advanced healthcare directives, I can definitely help you draft those. Again, that's something that is easier to do on your own, but you may have questions. You may just say, look, I don't want to have to figure out what all this means. Please just do it for me. And those can be done fairly inexpensively because they're pretty easy to do as long as I understand what rights your child wants to give away or get help with. That's a better way of saying it. And as long as I'm comfortable with the idea that your child really does understand what they're giving up. And that may involve a signed affidavit from you and the child that verifies that. But point being, as long as we're all comfortable with the child understanding their rights and voluntarily relinquishing those rights, I can definitely help with the powers of attorney, advanced medical directives. Special needs trust, I can help you draft those. Those kind of need to be worded carefully just to make sure that you get everything in there that you need and you have the protection that you need. And then long-term planning, again, the last two, I'll help with the special needs trust, obviously. If you have another estate planning attorney, I can work with them. I can also recommend one. If you don't have your estate plan up to date, that's definitely something you would want to do. You may have your estate plan already up to date and it just needs some minor tweaks to incorporate the special needs trust. And that's something I have no problem helping with, because if you already have a will drafted and we just need to structure it to where it includes the trust or maybe even essentially creates the trust upon the passing of the parent, then that's something we can certainly do as well. Long-term planning, again, full estate plan, maybe somebody else, but I can definitely take a look at your long-term plan and advise you on some of the things that you need to make sure, not just with estate planning, but just in general, some of the things that you really need to be aware of and make sure that they're in place to make sure that your child gets what they need. Because ultimately, that's really what this is all about. It's all about making sure that your child, no matter what their level of competency is, no matter what their level of cognitive ability, no matter what their level of physical ability, no matter what it is, it's about making sure that they're going to be taken care of no matter what happens. Because we don't like to think about the inevitable things, but the inevitable does happen eventually. And so it's very possible that parents might pass, and then it's like, what happens now with my child that struggles with these types of things? So this is all about peace of mind. It's all about you and possibly your child, depending on what they understand, but it's all about you having the peace of mind that you've put the pieces in place and you've put the people in place to make sure that if something happens that you can't help with for whatever reason, that mechanisms are automatically going to kick in to make sure that they get what they need, they're taken care of, and that everything just kind of continues as it should. So ultimately, that's what that's about. I am more than happy to do, as I said, individual free consultations to start with, just to figure out if there is anything that I can help with or if I can recommend someone else to help. Because ultimately, whether it's me, somebody else, at the end of the day, as I said, we're just trying to figure out the best thing for your children. So thank you for being here. Thank you for listening. Definitely appreciate it.